thing was unlike you. You're not here. On
Just
Zoom.
down the hallway.
Were you in the last hearing?
I did it by Zoom from 1:15 and had just enough time to get here.
Oh, that's great. Okay. We will go on the record in the matters 25 CF 148, 25 TR 880, 881, and 882. State of Wisconsin versus Jacob Hazeline. The state appears through District Attorney Kevin Schmidt in person. Mr. Hazeline appears in person with his counsel, Nicholas White. We're set today in this matter for a plea and sentencing. Mr. Hazeline has completed the IDIP program. Mr. White, is this proceeding as such?
Yes, it is, Your Honor.
All right. Plea questionnaire waiver of rights form.
Yes, I have that.
Has he had 48 consecutive hours?
Yes, he has, Your Honor. I believe it's 5 days credit from the arrest on the 10th until release on the 14th.
Can you recite the agreement for the record?
Your Honor, we have a joint agreement for a plea to the count 1, OWI as a 4th offense, merge and dismiss count 2, and it'll be the IDIP guidelines for the 0.25 or BAC or higher. That's the fine of $3,175, jail sentence 165 days, the 250 hours community service, and I'm not sure. I think it was the 36-month license revocation. That's not on the guidelines form or part of the negotiation, but I presume that's what would happen today, along with a waiver of the pre-sentence investigation.
Well, it's a lifetime.
I understand that. I was trying to explain that to Mr. Hazeline, that there's a difference between what Your Honor orders and what DOT or is expected to do, especially for work release, not being able to get that until 10 years.
Yes.
Okay.
So the court, it's an OWI 4th, and I have to order a lifetime unless the Department of Motor Vehicles. There's some ways that a 4th won't be a lifetime, but they only know that because that's through their system and their things. But when it comes in front of this court, an OWI 4th, I have to order a lifetime revocation. Okay, do you understand that?
Yes, Your Honor.
And do you still wish to proceed and enter a guilty plea here today?
Yes, Your Honor.
All right. So I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes, Your Honor.
Is this the document that your attorney went over with you?
Yes, it is.
Did he essentially go over it with you word for word?
Yes, he did.
And so you understand everything on this document?
Yes, Your Honor.
If by chance you didn't understand something, did you have your attorney explain it to you until you did?
Yes.
And is that your signature on the second page?
Yes, it is.
You're pleading guilty to 1 count of OWI 4th offense. You're 37 years old, 12 plus years of schooling. You can read, write, you understand the English language. You are not receiving treatment for a mental illness or disorder, no alcohol or illegal substances. However, you have had medications. Is that all correct?
Yes, Your Honor.
And have you taken your medications as prescribed?
Yes, Your Honor.
Do your medications interfere with your ability to comprehend or understand things?
No, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the minimums as well as the maximum possible penalties that you face?
Yes, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of the plea questionnaire. Do you have that in front of you?
Yes, Your Honor.
Did your attorney go over your rights with you thoroughly?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes, Your Honor.
You will no longer be able to vote in any election until your civil rights are restored. You understand that?
Yes, Your Honor.
All right. Here, the state would have to prove on or around October 10th, 2025, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
Yes, Your Honor.
And this is your fourth countable offense, correct?
Correct, Your Honor.
Upon conviction of this Class H felony, you could be fined not more than $10,000 and imprisoned not more than 6 years. However, you shall be fined not less than $600 and imprisoned not more than, or not less than 60 days due to your number of convictions. Do you understand that?
Yes, Your Honor.
Do you understand that there is an agreement that's been reached for the court to follow the Intoxicated Driver Intervention Program for a blood alcohol content of 0.25 or higher?
Yes, Your Honor.
Do you understand that I'm not bound to follow that agreement and that recommendation?
Yes, Your Honor.
I could sentence you all the way to that maximum possible penalty, which could be up to 6 years of incarceration. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? And in particular, the section, it's called the probable cause section, where it basically says what happened and why you were charged with the crimes?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty to an OWI fourth offense because you are guilty of that offense?
Yes, Your Honor.
Mr. White, may the court use the probable cause section of the criminal complaint with the statement made by your client to find a factual basis?
Yes, you may, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to the charge?
No, Your Honor.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your
Has
Honor.
your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
Has he looked at the discovery, which is the evidence and information in this case, and discussed it with you?
Yes, Your Honor.
Has he discussed with you a potential for any legal defenses or a lack of defenses in this case?
No, Your Honor.
What?
I'm sorry, what was the question?
Has he discussed with you any defenses that you may have? If this goes to trial, we can say this as a defense.
Yes.
And has he discussed with you a potential for no defenses?
Yes, Your Honor.
Are you satisfied with the services?
Yes, Your Honor.
Any questions for the court or for your attorney before I proceed?
No, Your Honor.
Has anyone made any, maybe I asked, any threats or promises to you for you to plead guilty?
No, Your Honor.
You're doing so freely, intelligently, and voluntarily with a full understanding of what you're doing here today?
Yes, Your Honor.
So no questions for the court or for your attorney?
I did have one question. So, I am having, a baby in September, and I was wondering if it would be possible to be at the hospital during my, monitoring.
What you will need to do at that time is you'll be talking with Miss Anderson
Okay,
and or Mr. Hatch about that. And then you'll just write a letter to the court and you'll let me know when it comes closer to that time.
okay,
Okay?
okay,
And that's something that the court would strongly consider allowing you to do because it's the birth of a child. But we'll see what happens from now to then, okay?
okay.
All right.
Thank you.
Any other questions?
No, Your Honor.
All right. Then as to OWI fourth offense, count 1, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up your rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1, OWI fourth. Count 2 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Before we get to arguments, Mr. Hazeline, did your attorney go over with you that you can convert the 250 community service hours to extra jail days or monitor days?
Yes, Your Honor.
Okay, so you've considered that and you would be able to let me know a possibility of what you wish to do?
Yes, Your Honor.
Okay. Mr. Schmidt, argument and sentencing recommendation, please.
Thank you. I think this person has earned the IDIP guidelines in addition to completing the program, which is confirmed by Tessa Anderson. His prior OWIs were very long ago. They were 08, 09, and 11, meaning he's already shown a very long period before it happening again, which I think cuts in his favor. So I'd ask the court to follow the recommendation. Thank you.
All right, Mr. White.
Your Honor, I'd ask you to follow our recommendation here, as the prosecutor stated, and we can see with the IDIP completion form that Ms. Anderson filed in this case, Mr. Hazeline has completed the monthly appointments, random drug tests, the AODA assessment, victim impact panel, and community service, at least what he was required to do ahead of time. He's been following the rules. He's been on bond for quite some time now. No new issues. For protection of the public and severity of the charge, I think that all goes towards this IDIP recommendation. Just for his character and rehabilitative needs, my client is, I think, moving towards a lot more serious position in his life. He's having a child that's due in the fall. He's also informed me that he's been promoted at work to, I believe, a management position. That just implies some trust and responsibility on his part. I see two people here. I did not speak with them, but I believe that his parents are here in support. It shows just that he does have some help. And I think that upon release from the jail and monitor program, hoping that won't see him again in court. Thank you, Judge.
Thank you. Mr. Hazeltine, anything you want to add, you want to tell me?
No, Your Honor.
Okay. OWIs are serious, and OWI 4th is extremely serious. As you can tell, not only has the legislature increased it from a misdemeanor up to a felony now in the last few years, but they have also included a lifetime restriction from driving, lifetime revocation from driving, except for in 10 years, if you do this, that, and the other, and the Department of Motor Vehicles believes that you qualify or they think that you're good enough, they would give you an occupational license at that time, but you can't ask before 10 years. It's serious. You put your life at risk. You put other people's lives at risk, and definitely not safe to do. It sounds like you are getting your life in place and on the right track. It sounds like you're doing well in your job and you're improving there, and you're going to be a father, and there's all kinds of positive things in your future. Hopefully that's going to be enough to keep you on the straight and narrow. I think that the agreement is appropriate, so the court will follow the agreement. $3,175 in fines and fees, 165 days of jail, 250 hours of community service. Before I get to the rest, have you considered, do you wish to do the community service or have it converted to additional jail days?
I would have it converted.
You would like to do that?
Yes, Your Honor. I work like 45-hour weeks, and I
Makes
live
sense.
like an hour away, so there's
I'm
not a
fine
whole
with
lot of
that.
extra time.
That's why I give the option.
Yep, thank
So
you.
it'll be a total of 197 days of jail without having the community service requirement, lifetime revocation of your driver's license. And this is where I'm unsure, Mr. White, if I'm supposed to order the AODA assessment and the driver safety plan.
So this is, I think, what Attorney White was hinting at. The court isn't actually an entity authorized to revoke a license for life. The court
Well-
is only allowed to revoke his license between 2 and 3 years. It's that once DOT receives record of this revocation, DOT has the authority to revoke for life. I
Okay,
can give you the statutory citations for that if that's needed.
well, that's fine. I don't know what I'm supposed to do or what I'm not supposed to do because
We're
they
asking
don't
for
give us.
We're asking for a
idea.
3-year license revocation, which is the maximum of what court can do under 343.30 sub 1Q sub B sub 4. And then the court, can warn people that as a collateral consequence, DOT will revoke their license for life under 343.31 sub 1M sub B.
All right, so 3 years revocation of driver's license, 3 years ignition interlock device. OWI assessment and driver safety plan. Then that means I have to order it and then you have to do it and it could be a violation if you don't. Take it up with the legislature. You do have $3,500 cash for your bail bond. So plus there's a $10 blood draw fee, so I have to do that. So you should be all paid. Oh, no, you shouldn't be. The remaining amount of money can be transferred to the electronic monitor program to help pay because you have to pay at least 30 days in advance. I'm
Okay.
going to tell you, you can't pay late. It has to be paid on time. Otherwise, you do have to go sit the time in jail. It has to be 30 days in advance. Or you can pay it off all in full at that time. When you're on the monitor, you may not have don't be around any rubbing alcohol, don't have your monitor around gasoline or anything that could set it off, that it has been or is near alcohol, because it will do 24/7 testing of your sweat on your skin. I've not been proven or disproven that if it's around rubbing alcohol or things like that or touches it, that it sets it off. If it does set it off and indicate that there has been alcohol or that there has been a detection of alcohol, you will be told that you must immediately go to the jail and you're going to be revoked from the monitor. No good time, no Huber. Very important that you do those things. I would not eat anything that is made with alcohol, such as chicken marsala that uses red wine and those kinds of things that could still set off the monitor. So be very careful, okay? And probably don't use mouthwash because some is made with alcohol, okay? Rubbing, whatever alcohol that is, because that could set it off. I don't know if it will for sure. I have not tested it, but I just want to make sure that you know to avoid those things for this amount of time, because you don't get a due process hearing, or there's no kind of hearing that you get to say, Judge, I didn't do it. I promise it wasn't me. It was something else. Okay.
Okay.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The rest of the money will be transferred to either Tessa Anderson or Dave Hatch for helping pay off the monitor. I need to order your DNA. You need to provide that to the jail. You're going to go get booked in today, and you're going to provide your DNA. You have the right to request it be expunged through a written letter to the Department of Justice. So go ahead and do that. And then follow all the rules and procedures for the monitor.
And just like that, the hearing comes to a close, but the real consequences are only beginning. This case is a powerful reminder that in the courtroom, accountability goes far beyond a guilty plea. The judge balanced punishment with the hope of rehabilitation, recognizing the defendant's progress while making it clear that repeat impaired driving carries life-changing consequences. Do you think this sentence struck the right balance between justice and second chances?
You can have Huber release, go to work. You can go to doctor's appointments. You can go to AA. But if there's anything else, that you need to do or that comes up like a funeral, you can't go unless you ask for the court's permission. And I don't always grant it for things. So it's better to make sure and hopefully have your life planned out already. I think that covers everything, Mr. Schmidt.
Nothing from me.
Okay, Mr. White.
As long as the sentence credit was noted, I think that was everything.
5 days, yep, 5 days sentence credit.
Okay.
Thank you, then we are adjourned. Why didn't you bring that up like 4 years ago when it changed and I have to say the things, Mr. Schmidt? It's been 4 years.
I mean, you should say it just like you should say like immigration consequences, but you don't order people deported.
Lifetime, a
Hmm?
lifetime revocation. I
Yeah.
always say it on OW 4-5. No one's ever said anything different.
I just didn't notice.
'Cause we're told to say it.